Hello and welcome to this week's episode of Crystalcast. My name is Ross.
My name is Juan.
It's so good to be here. We've got quite a few things to discuss today. Our main topic of the week, Juan, this week is the Genuine Study Test. So I really want to get into the nitty-gritty and also compare it to the Genuine Temporary Entrant criteria and have a bit of a discussion. We've got random question of the week and we've got our news.
Yes.
So let's get this started. And now we'd like to thank our sponsors who support us every week to bring these episodes to you free of charge.
And they are Migration Insurance Brokers, 123 Accounting.
And we've also got Oasis Keen, Migration Strategic Brokers, and Talk to a Broker.
Alright, speaking about the news this week, Ross, I would like to mention the changes for the English test requirement for student visas and foreign flight visas. They're going to apply these changes from the 23rd of March, so they're live now. And basically they change or they increase the requirement for 0.5 high.
Yes, it's not terribly a huge score, but I think it is probably worthwhile mentioning.
I'm going to tell you something though, like I'm... As English is my second language, I feel, the nervousness that people is feeling at the moment, or applicant students. Yeah, it's little, but at the same time, I want to encourage people that have to do the test not to feel dismay, because it's not that much, and yeah, just going on the specific, Ross. Previously, the IELTS or equivalent was for student visa was 5.5.
Yes.
And now it is 6 for those studies that don't require ELICOS or English course as part of the package.
Yeah.
Or as part of the studies.
And I think also, just to be clear as well, this is IELTS or equivalent. So if you wanted to do another test, if you feel more comfortable with PTE, people can still do that. They don't need to do IELTS, because I think there was a bit of confusion on Home Affairs website. It mentioned IELTS, but you can still do all of the other prescribed tests. It's just IELTS is used as a benchmark, so people don't get confused. Yeah,
absolutely. And in the specific for the postgraduate visa, the IELTS or equivalents used to be 6, and now it's 6.5. So again, just that 0.5 requirement.
But as you said, it could mean, potentially a little bit more study. So, and we've got all this information on our blog, crystalpress.com.au. If you want to visit it, we put all of our articles live there, so they can keep up to date. But I wanted to ask you as well, and I know we get these questions a lot. The first one that I get is, well, which test is easier? Should I do IELTS, PTE? What are your thoughts on this?
Well, Ross, look, I think it's about preference.
Yeah.
But it is all about how you prepare and how you get familiar with the structure of the test.
Yeah, exactly.
Because it's not about how much or how perfect your English is, but it's about how well you know the structure. And I can speak about my own example. I was very nervous before doing my English test, but then when I saw the structure, when I was reading articles about how to prepare, how to know what sort of questions were going to be in the test, then I felt way more confident. Because again, it's not about what test you do.
Yeah, exactly. And I suppose it is an exam, so you wouldn't go in there thinking, well, I can speak the language, so therefore I don't need to study. I think that's probably the most important thing. The other thing I wanted to mention as well is, yes, you do have different tests. You got IELTS, you got PTE, TOEFL, but all of these tests, just in terms of how they rank proficient, superior, competent, there is actually a common denominator that these tests decide. So it's not necessarily that IELTS is harder than PTE. Like you said, it's got to do with the preference and also the test structure. So they are structured differently, so depending on which test you prefer, and you would only know if you looked at the test criteria, that's what will appear to be easier or maybe more compatible to you. That's probably the better word to use.
Yeah, and the good thing as well is like there is plenty of material
100%.
in the internet that students can go and so they can get familiar with these structure tips, YouTube videos. There's heaps of material, so don't get discouraged by this increase.
Yeah.
I think
And,
because
and there was one more thing about the test duration being now lower, correct?
yeah, the validity of the English
Validity,
test,
yes.
which to be honest, I think it's not a great thing because come on, you're not gonna forget a language, especially if you live in the country. If you live in Australia speaking English all the time, I don't think you're gonna forget, you know, or
Yeah,
if
I would have to agree, yeah.
if you prepare yourself for the test and you already passed it,
Mm.
I don't think you're gonna lower your proficiency, you know?
Yeah,
So I think it's a bit of a way changing fair, I don't know, but
yeah.
it is what it is.
And that's just for the graduate visas, correct?
Yes, that's
Okay.
correct.
Yeah. And if you've lodged the 485 visa, the changes are not retrospective, meaning that these changes apply to new applications going forward.
That's right. That's right.
Now, Juan, this week we had quite a few changes in relation to student visas. As part of the migration strategy, we've discussed this before, the new genuine study test has come into effect, and all of this is spelled out in Direction 106. So what I wanted to talk about today is just some of the key differences between the old direction and the new one. So perhaps maybe we can just give a bit of an overview as to what the previous rules were in Direction 69. So what sort of things did the Department of Home Affairs look at before the new test came into effect?
Yeah, Ross, that's a good question. So before, the department was making focus on the genuine temporary entrance statements from the applicants of
Yeah.
student visas. They were making focus on how long you want to stay, if you wanted to stay temporarily, or if there were, signs that you were trying to stay longer.
Yeah.
And so there was a heavy focus on that.
Yeah, and I think that was a bit subjective as well because I suppose the case officer would have to use their discretion to determine whether you are going to stay temporary in Australia or whether you're going to apply for another visa. And I think one of the things we talked about, the issue is that you do have the 485 visa, which is a temporary graduate visa, which sort of leads off the back of a student visa. Now, we've got a new test, which is in Direction 106, the genuine student test or the genuine study test. Now, this particular test, what it's focusing on, it still takes into consideration the 5 pillars, so applicant circumstances in the home country, circumstances in Australia, the relevance of the course. There's also a pillar in relation to minors, but the one that has sort of stood out for me is any other relevant factors. So this is where the key difference between the two directions lies. So when you look at other relevant factors, there is now certain criteria. So say, for example, if you applied for a student visa before, and this is your second application. So what the case officer would be looking at is, did you study the course? Have you completed the course? Did you participate in any assessments or activities? And I suppose maybe off the back of that as well, if there was an issue with the education provider and they might have issued a notice of intention to cancel a COE, all of that's going to come into play.
So there's a difference. There's more focus on the study per se, as opposed of the intention of staying longer or not.
Yeah, definitely, and that's where that last point, any other relevant factors, I've always had an issue with that because the previous direction basically stated, well, whatever the case officer deems to be relevant, they can refuse the application. Whereas now, there are certain parameters under which the application could be refused. To me, I think that's a good thing. I think we're going to probably see less refusals. But I wanted to ask you, what sort of advice should we give to individuals who have lodged their application prior to 23rd of May?
Well, they're gonna be
I just realized I said 23rd of May again.
ah.
So we'll cut that.
Yeah,
Yeah.
just
Is
that.
that okay? Yeah.
Yeah.
And it's not advice. How will the applications be assessed that were launched prior to 23rd of March? And I just wanted to ask you as well, Juan, what about applications that were lodged prior to 23rd of March? How will they be assessed?
Well, Ross, just like in any other visa changes, those applications are going to be assessed according to Direction 69,
Yes.
so the old direction. And so the focus is going to be on the genuine temporary entrant. And yeah, so there is no worry for those applications. Now, Ross, another aspect I wanted to discuss was the statement.
Yes.
Because I know now they're putting a limit of
300 words. Yes.
and that's a bit of a big one, because before, we know the statements and general temporary statements would be huge. It would be like a big document.
Yeah, it was a bit of an essay.
Yeah, a bit of an essay, and there were a lot of the time it seemed like it was too fabricated.
Yeah, and then look, I don't want this to come across in the wrong way, but I would have to agree. A lot of these templates before were templates.
Yeah.
It had this particular structure where the applicant would say, well, I want to study a particular course. So what comes to mind is childcare. The ones that I've read is I want to study childcare. I want to go back to my home country and basically open up my childcare center business. And, the applicant has no prior experience in managing a business or opening a business. And I think the reason why individuals would write that is because it was quite stringent criteria that focused on show us that you're going to return back to your home country.
Yeah.
And I do think it places a lot of people in that difficult position. So the focus now is not on what you're going to do after you finish the course, but more on why you've chosen that course and if there's any other factor before the Department of Home Affairs to suggest that you're not going to study. So I'll give you two examples to illustrate it. Let's say if you've got an individual who's never applied for a student visa before. They haven't studied in Australia. So based on the new direction, the case officer would need to take on face value that 300 word statement, why they're coming to Australia, why they've chosen that course, and why it's relevant to them. Because there's nothing else to sort of discredit that.
Yeah.
They haven't studied here before.
Yeah.
So that last criteria about any other relevant factors won't apply. But if you've got someone who has studied in Australia before, well, they would be in the second cohort because the case officer would need to look at the compliance. So if you studied before, have you completed the course? Have you deferred the course and why? And if you are one of those individuals who's completing short courses, that doesn't really have any cohesion. So I think for these individuals, it will be a bit harder to apply for a subsequent visa. But if you're a first-time student visa applicant, it should be a fairly straightforward and streamlined application. Yeah. And Juan, just in relation to the 300-word statement, I know it's still early days, but what would be your recommendation? How should one structure it?
Well, I believe, Ross, that it would be really important to make sense on what your plan is.
Yeah.
If you're doing a course right now, is it going to make sense to change the course completely?
Yeah.
And if you're going to do it, how are you going to justify it?
Yeah.
So my recommendation is have a look at this direction 106.
Yeah.
And see how your plan in Australia is going to align with this direction.
Yeah.
Is it making sense? Is it going to benefit you? Or perhaps there is another option for you.
Yeah.
So
yeah, definitely.
I think there has to be a focus on that.
Yeah. And I think, I know you mentioned, well, we both mentioned before about those elaborate GTE statements. Maybe perhaps try to keep it simple as well.
Yeah, absolutely.
Don't overcomplicate it. And we deal with refusals where clients come to us that have lodged the applications themselves, and these applications are refused based on GTE.
Yeah.
And the common factor is that the statement didn't make any sense.
Yeah, exactly. Reminds me of a case, Ross, where a student was just saying that they it was evident that they didn't have the finances to cover the cost themselves, so they were getting help from relatives. But in the GT, they stated that they wanted to open the restaurants like in 2 years' time. After starting the course,
yeah.
the whole restaurant, like it's a huge finance that you have to put.
Yeah, 100%.
And then they came to us, wanting to represent them at the tribunals because the visa was refused.
Yeah.
And the refusal was obviously based on these
on the GT
on
that the person's right.
That
Yeah,
didn't
exactly.
make any sense. So I think now that this statement with 300-word limit is gonna encourage you not to include those nonsense.
Yeah, 100%. And I really like your tip about actually reading that direction. So if you're going to be doing the application yourself, I wouldn't rely just on what is on the Home Affairs website. You do need to look at the instrument, so it's Direction 106, and really understand what the case officer is going to be looking at, because they don't assess applications by looking at Home Affairs website. They look at the legal document. So it's really important that you understand what will be assessed and you
100%.
don't overcomplicate the process. Yeah.
Absolutely.
And I suppose we just need to sort of wait and see how this will be assessed in practice. We've discussed a couple of weeks ago the FOI statistics on student visa refusals, and it sits at around 20% at the moment. So it would be interesting to see maybe in 6 months' time whether that refusal rate will go down, because proportionally speaking with other temporary visas, it is quite high.
It is.
You'd want it to be sitting around 5%. So it'd be good to see if this new test will be bringing down the refusal rates, but it's still early days.
And now this week, we're going to be reading out loud, Ross, the question of the week.
The random question of the week, it's back.
Yes, absolutely. So it is, how can I start talking about potential visa sponsorships from my employer? I'm working in a large company which has a history for sponsorship. Is it better to start with my manager or with HR first?
That's a good question, and we get those questions pretty much all the time from visa applicants saying, how do I initiate that conversation? I always say to visa applicants, there's two things that an employer wants to know. The first one is how much it's going to cost them and what sort of documents are involved. So I suppose to initiate that conversation, it's a good idea to come to them prepared with those answers. So what I would be recommending doing is, first of all, check whether you're eligible to apply for the visa. I know there's a huge push at the moment for TSS visas, 186 visas. People want to apply for direct entry because they want to get PR sooner, but it is an employer-sponsored visa, or an employer-sponsored program, I should say. So you kind of need to not just think about your eligibility, but your company's eligibility. So my strong recommendation would be to do the assessment first, and that way you'll have an idea of what sort of pathway you're eligible under, and also when you can apply. And once you have that information, yes, I definitely would speak with the line manager, because generally there would be some sort of global mobility policy in place with larger businesses, and that line manager would then be able to escalate it to the correct person. But they would need to sort of have some sort of understanding in terms of how the process works. Because what could also happen in these circumstances, if you go away and don't tell the employer that you're getting, this advice and that you're eligible, it could get to a situation where you might be eligible, but the business might have a policy where they just don't offer sponsorship. So I think it is important to do a little bit of research and then go with your employer and say, look, these are the options. How can we take it from there? And the majority of employers will support it, but they also have their own policies in regards to how that program is going to be implemented.
Yeah. So the key answer here is like to be prepared to
100%.
make a proposal with preparation.
Yeah.
And knowledge behind it.
Yeah, 100%.
And at the end, like often the sponsor or the employer may want to speak to us, to a lawyer, to a migration agent.
Yeah, 100%. They might want to speak with a migration agent or a lawyer. They might have their own team as well, so that's another thing that's important to consider. And they might actually have a policy in place. So, all of these things need to be taken into consideration. And starting off a conversation with your direct manager would be the way to go. And if they're not the right person, then they will escalate it to the person who'd be able to assist. Great question. And if there's any other questions that you would like to be featured on our subsequent episodes, send an email to us, inquiries@crystalmigration.net, and we'll take it from there.
And there is a prize for that.
There is a prize, yes.
Yeah, so we're gonna be doing random selection of all the people that gave us questions, and the selected person is gonna win $300.
And we'll do it live on air on our last episode.
Thank you so much for being with us today. That's bringing us to the end, and we're gonna be here next week with you.
Thanks so much, Juan. It's been a pleasure as always.
Thank
Same
you.
place, same time next week.
Yes.